pledge. Okay, hello everybody, and welcome to the final Federalist Society event of this semester. This is our 9th event, and we're very happy at all of you in attendance and all of you who've attended our events this semester. My name is Aslam Rauf. I'm the president of the Northwestern Law Federalist Society. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on the law and public policy. We, as you all know, are having a debate today on the topic of drone strikes and targeted killings. You may remember earlier this year, last semester, Attorney General Holder himself came to Northwestern Law School and delivered a speech defending the administration's rationale for drone strikes, which some of you found persuasive and some of you didn't. Hopefully we can highlight the different arguments today. For that, we have two esteemed scholars on the topic today. First speaking for 20 minutes will be Professor Mike Lewis from Ohio Northern University Law School. He is a former Navy flyer and Top Gun graduate, and he teaches international law and the law of war. He has also testified before Congress on the matter of drones and the use of military commissions by terror suspects. And we also have Northwestern's very own Professor Stephen Sawyer here. I would like to thank the Veterans Association of Northwestern Law School. Lisa is here. She's been very helpful in getting Professor Sawyer involved in this event and helping us co-sponsor the event. So please note the efforts of the Veterans Association. Stephen Sawyer is a Northwestern Law professor, as I mentioned before. He is a senior counsel with the Center for International Human Rights, and he is the director of clinical projects here at Northwestern University, and he is an expert on public international law. So after Professor Lewis speaks, then Professor Sawyer will speak for 20 minutes, and then we'll open it up for a robust question and answer session. So without further ado, please join me in welcoming Professor Mike Lewis.
Thank you, Aslan, and thank you to the Federalist Society and the Military Law Society for having me, and thank you to Professor Sawyer for agreeing to make this into a debate rather than a lecture. I think that you are all much better served by hearing both sides of this as an argument rather than merely me telling you what I think about something. The topic is drones, and what I'm going to be talking about mainly is their legality. The threshold question of their legality is actually fairly simple. Drones are manned aircraft, and the legal requirements for drones are identical to legal requirements for manned aircraft. Where you can use a manned aircraft, you can use a drone, and vice versa. The same necessity and proportionality requirements that any manned aircraft has to meet before it releases weapons, drones would have to meet as well. And the operators that are operating hundreds or even thousands of miles from the battlefield would actually be treated as combatants. It doesn't really matter whether they are wearing uniforms. There's a lot of back and forth on that. Who cares? Because what you need to distinguish is not the operator, but the drone itself. The drone cannot look like a civilian aircraft so that it does not cause confusion there. But the operator is a legitimate target, and a combatant. This legal equivalency between armed aircraft and drones works as long as drones are what I would call tethered. Right now, any drone strike, any release of a weapon by a drone is done when a human being pushes a button or pulls a trigger. If drones become untethered, in other words, if drones are able to make weapons release decisions themselves, things become much more complicated. That is an untethered drone. And that is one of the reasons why people have great fear and distrust of drones, because there's a sense that we are marching down toward that kind of future. Now, as long as they remain tethered, and I will tell you that there is no one that I have met at any level of the military that has any appetite for removing the weapons employment decision from human beings. And we'll see for a variety of reasons why that is so. But while the technology might be getting closer to having artificial intelligence make weapons release decisions, there is no indication the military has any appetite or interest in actually taking those decisions out of the hands of individuals. Now I'm going to skip the drone's advantages and disadvantages because for sake of time I want to make sure that we have plenty for you to ask questions afterwards. But the drone's application is very important. Drones work very well in permissive air environments in which there is not surface-to-air missile threat, in which there are not manned aircraft out there. And the other thing is that they only work in wartime. And this is the most important thing. Anytime you have a drone strike happen, one of the things that that means is that the people using the drone strike, employing the weapons, are assuming that the laws of war apply. That's the biggest indication, because drones are only tools of warfare. Armed drones cannot be used in a law enforcement context. That's what drones tell us, the scope of IHL. IHL, International Humanitarian Law, also known as the laws of war, think Geneva Conventions. Where does that law apply? Anywhere a drone is striking, that has to be based on a belief that IHL applies there. The other type of law, human rights law, IHRL is what I have up there. Human rights law applies universally at some level, but is displaced in certain situations by the law of war. The best example of that is when it comes to the use of lethal force. The government can use lethal force against you here in Chicago today if certain requirements are met. If you are dangerous, if you become dangerous to other people and law enforcement officers, they can use lethal force against you after offering you an opportunity to surrender. That's human rights law. They offer you an opportunity to surrender. They may only use lethal force against you if you are threatening others with lethal force. Right? Now, IHL is different. IHL, the laws of war, say that you can kill, you can use lethal force based on status. That is, a positively identified enemy can be killed. And they can be killed whether they are armed, whether they are imminently dangerous, whether they're asleep or awake. It doesn't matter. Positively identified enemy can be killed during wartime, regardless of whether they are dangerous. And this is the way that drones are used. Drones can't offer an opportunity to surrender. Therefore, anytime you're using a drone, you have to believe that the laws of war apply in the place where you are using the drone. And this is a huge source of contention between those that argue that strikes in places like Yemen and Pakistan are illegal, and those that argue they are not. The United States, Attorney General Holder, and others who have spoken on this, State Department General Counsel Coe, and Brennan, who is the counterterrorism assistant to President Obama, have all argued in one way or another, some of what you're going to hear today from me. Now, there are two types of armed conflicts. When you have IHL, you divide the world into two. There are international armed conflicts and non-international armed conflicts. International armed conflict, traditional France versus Germany, two nation-states going to war with each other. Non-international armed conflicts, NIACs, are, or at least were up until 9/11, considered to be exclusively civil wars, right? Internal conflicts of a rebel group of some kind against the government. The problem is that where we have found ourselves is in a third type of conflict called a transnational armed conflict. But let's look at the two traditional ones first. How do international armed conflicts determine the boundaries of their battlefields? They use neutrality law. Neutrality law says that non-belligerents are not allowed to host belligerent troops. They are not allowed to allow belligerent troops to go through their territory. They are not allowed to allow recruitment of belligerent troops from their territory. And it is incumbent upon the belligerents themselves to avoid neutral territory. That is how we bounded the battlefields in traditional international armed conflicts. And the way, if you wanted a one-liner on that, international humanitarian law goes where the participants in the armed conflict go. An example of that would be the Graf Spee incident early in World War II. German commerce raider runs into some British cruisers, exchange gunfire, the Graf Spee is damaged, and goes into the neutral port of Montevideo in Uruguay. The British and French say the Hague Convention on Neutrality Law in Naval Warfare requires you to get the Graf Spee out in 24 hours. Belligerent warships are only allowed 24 hours in neutral ports. The Germans say we are damaged and we must be made seaworthy before we leave our port. We need 14 days. The time it would take for German U-boats to come from the North Atlantic and help them break out through the British cruiser screen. So both sides are pummeling on the Uruguayan foreign minister saying, you need to get them out, you need to let us stay. And the Uruguayan foreign minister says, we're neutral. We are not going to do what either of you are telling us to do. We have neutral obligations. Our neutral obligation is to make sure the Graf Spee is seaworthy before we send it out and to get it out of our port as soon as possible after 24 hours. Now, they said you have 72 hours. They inspected the ship. 72 hours later, the Graf Spee had to leave. Rather than leaving, it was scuttled in the harbor rather than fighting a hopeless battle against the British cruisers outside the mouth of the river. And the German crew was interned in Uruguay for the balance of the war. Uruguay is neutral. They have a duty to intern belligerents that are found on their territory. Now, NIACs, non-international armed conflicts, the boundaries of those battlefields are determined by what are called the Tadich factors from the ICTY case of that name. And it talked about determining where the boundaries of the battlefield are based upon the level of violence in that geography and the cohesion of the armed forces there. The thinking behind this is we do not want to say the law of war applies everywhere just because there's a rebellion going on in a little portion of the country. Because the laws of war allow things that we don't like. They allow detention without charge. They allow the use of lethal force based on status. If you do those things, mistakes get made that we don't want to make any more than we have to. So this is how we bound the battlefield in non-international armed conflicts. And this actually harkens back to our own Civil War. Long before NIACs or IACs or even IHL was discussed. But if you are familiar, many of you may be, with the case Ex parte Milligan, in which a Confederate sympathizer was captured by the Union forces in Indiana and was tried by a military commission. And the Supreme Court said, no, you may not hang him based upon the military commission result because he's in Indiana and the courts are open in Indiana. And where the organs of civil society are working, you should make use of them. Yes, there's a rebellion going on. We have a war happening, and military commissions are appropriate in some areas. But where civilian institutions are still operating, you must avail yourselves of them. Right? The Tadich factors say essentially the same thing. If the level of violence and the cohesion of the armed forces is not such that it closes down civilian institutions, you have to have resort to those institutions. That's how you determine the boundaries of the battlefield in a NIAC. The problem is, and until, as I said, 9/11, NIACs were considered to be exclusively internal struggles. And in those sorts of struggles, Tadich makes perfect sense, just as I outlined in Milligan, right? You don't want the boundaries of the battlefield to be any further than necessary. You want human rights law to apply as broadly as possible, even during a rebellion or a civil war. The problem is that what we're involved in now between the United States and Al-Qaeda is more aptly described as a transnational armed conflict. It is a conflict between a non-state actor and a state that crosses international boundaries. Al-Qaeda can't be found in the United States, at least not largely. It was never sort of headquartered there, and it still is largely its center of gravity. Might be Afghanistan, it might be Pakistan, it might be Yemen today, but it is certainly not in the United States. Now, the Hamdan opinion unfortunately, I think probably from all sides at this point, has labeled this conflict a NIAC. And I think a lot of people on a lot of sides, both those that oppose and those that support the use of drones and the other arguments we're making today, have a real problem with the fact that Stevens, in a very short-handed way, made that determination. But as I say, a better description of this is as a transnational armed conflict. So the question is, what should the boundaries of the battlefield be in a transnational armed conflict? Well, there's the al-Awlaki case that you may have heard about or been aware of. An American citizen in Yemen, operational leader of Al-Qaeda in the Arabian Peninsula, not the leader, but one of the operational heads of that group, who, among other things, had spoken to and told Abdul Muttalib, the underwear bomber, where and when to detonate himself over Detroit, who spoke with Major Hassan before he killed the people at Fort Hood, etc., etc. So that is his role. And the United States targeted him. They said, we're going after him with a drone. The ACLU filed suit saying we should enjoin that because this is occurring outside the context of armed conflict. Yemen is not a place where the Tadich factors back then are met. There's not the cohesiveness and there isn't the level of violence going on in Yemen to apply IHL there. You have to apply human rights law, and if you apply human rights law, you can't use lethal force unless his threat is imminent and you offer an opportunity to surrender. Drones can't do that. You should be enjoined from using drones against al-Awlaki in Yemen. That case was dismissed on standing and political question grounds, and al-Awlaki was killed by a drone last September. So the question is, should the ACLU's argument that the Tadich factors determine the scope of a transnational armed conflict, should that be the way we look at it or not? To understand the problems with using the Tadich threshold in transnational armed conflicts, it's important to understand how IHL, International Humanitarian Law, the laws of war, generally treats the people involved in those wars. Right? The question right now would be, is the Tadich threshold met in a place like Pakistan or Sudan or Somalia or Yemen? If it's not, human rights law applies, the law of war doesn't apply. That would be the ACLU's argument. To understand what that means and why applying Tadich to transnational armed conflicts essentially turns the Geneva Conventions on their head, you have to understand how the Geneva Conventions work. IHL's primary purpose is to protect people who can't protect themselves. Civilians, those who are captured as POWs, those who are wounded in combat. And it divides the world into two groups, civilians and combatants. Who's a combatant? Not somebody who just picks up a gun and starts shooting. A combatant is a member of an armed group that has a command structure that enforces the laws of war. If your command structure does not enforce the laws of war, you're not a combatant. Even if you obey the laws of war personally, that doesn't matter. You have to be a member of a group that enforces the laws of war against its members. If you don't do that, then you are not a combatant. What's the advantage of being a combatant? You get to use force, and you are not criminally liable for using force. As long as you don't violate the laws of war, things you destroy and people you harm are not people that can then come back against you criminally and claim murder or assault charges or malicious destruction of property charges. The downside of being a combatant is you're targetable 24/7, right? Positive ID, doesn't matter if you're asleep, doesn't matter if you're unarmed, you are targetable. Everyone else is a civilian. Civilian is not actually defined by IHL, it is defined negatively as all those not combatants. The advantage of being a civilian, you are not targetable, ever. You are never targetable as a civilian, but you may not participate in hostilities. Now, if you do participate in hostilities, direct participation in hostilities, DPH, if a civilian DPHs, I don't know if that's a word, but I'm going to use it, if a civilian DPHs, then they temporarily or permanently lose their immunity. You either lose it for the time that you are actually committing the hostilities, or if you do the revolving door, farmer by day, fighter by night, and you do that regularly enough, or you become a leader of a group like Al-Qaeda, then you permanently forfeit your civilian immunity and you're targetable. That doesn't mean you're a combatant. You don't get combatant status just because you've done that, but what you are is you are now a civilian that has forfeited their immunity. And the only way you can get that immunity back is if you disassociate yourself with Al-Qaeda. I'm no longer part of this group. I'm not doing what I was doing before. I am disassociated from Al-Qaeda. I want my immunity back. And you can get it back that way, but you have to be very clear about the fact that you are no longer part of this group. Right? Now, if you apply TADIJ to transnational armed conflicts, there is another way for leaders of Al-Qaeda to regain the immunity that IHL takes from them because of the fact that they are doing the things they do. And that would be simply crossing a border. If I can get to Somalia, if I can get to Yemen, if I can get to Sudan, if I get to some place where there isn't the TADIJ level of violence going on, I can't be targeted under the laws of war. And guess what? Law enforcement doesn't work in this part of Yemen or this part of Sudan anyway, so I've effectively regained my immunity, not by disassociating myself from Al-Qaeda, but merely by crossing a border. And that is not an acceptable way of reading IHL, in my view, if there is an alternative. Is there an alternative way of bounding the battlefields and limiting where the laws of armed conflict apply in a transnational armed conflict? The answer to that is yes. You apply neutrality law to determine where the boundaries of the battlefield are. And that would be to say, for example, to Yemen. You have a choice. You can be an ally, an enemy, or a neutral. Ally would be, you can tell us to come on in and strike in your territory. You have the sovereign right to do that, and WikiLeaks cables and other things have indicated that that is what Yemen has been doing. Yemen has been giving us permission to come in. Be like Uruguay telling the Brits, come in and sink the Graf Spee in our harbor. But you're no longer neutral. The flip side would be to be an enemy. And an enemy would be Afghanistan after 9/11. We said, you have Al-Qaeda in your country, you have to get them out of there. Right? Otherwise, you're not discharging your neutral obligations. Mullah Omar and Osama bin Laden are not allowed to remain in Afghanistan. And the Taliban's choice was, no, we're going to defend them. You can't have them, and we are not going to expel them. And so when we invaded Afghanistan, we didn't only go after Al-Qaeda there, we went after the Taliban as well, because essentially they had become an enemy. In the same way as if Uruguay had told the Brits, no, we're going to protect the Graf Spee for as long as it needs to be here, then they are essentially declaring war on Great Britain by taking sides. The last one is neutrality. You could be neutral. I am an independent, sovereign nation, and I don't want you dropping bombs on my territory. I have the absolute right to tell you not to. However, I have an obligation, if this is the type of law that we're applying, to ensure that my territory isn't being used as a base of operations by your enemy. So if Pakistan makes sure that the Taliban and that Al-Qaeda are out of Pakistan, then we can't drop bombs in their territory if they're not giving us permission. But the bin Laden raid was a classic example of the unable or unwilling standard that we've seen people like Holder, like Brennan, like Coe talk about. If you are unable or unwilling to discharge your neutral obligation, then we can use force on your territory in spite of the fact that you don't give us permission to, because you are not living up to your responsibilities as a neutral. And that would be the basis for the use of force there. Now, this does not determine whether there's a conflict between us and Al-Qaeda. That's determined by the level of violence between the U.S. and Al-Qaeda, not by the application of neutrality law. And it doesn't mean that strikes in Yemen or Pakistan are necessarily legal. It just means that they either require permission or they require a showing that the host nation is unable or unwilling to properly discharge the neutral obligations. But claims that the boundaries of the battlefield are such that they forbid the use of force on their territory really need to end, because that is not a realistic way of understanding IHL. Thanks.
Good afternoon. It's a pleasure to be here to talk to you on this critically important subject matter. It's important for us as students of the law. It's important for us as American citizens. It's important for us as citizens of the world. These are highly controversial questions that we are going to discuss today. The idea of deliberate plotting to kill an individual is a terribly important subject matter that needs to be accomplished, if it is to be accomplished at all, within the framework of a rule of law. What I have sought to do in my presentation is to set forth some propositions that constitute a framework for debate. I think, as I listened to Professor Lewis make his presentation, that there's not much difference between us with respect to the legal principles that apply. There are bodies of law that we must consult as lawyers to determine whether the deliberate, intentional killing of another can be justified. We need to examine the law as it exists under the Constitution and statutes of our country. We must examine the law as it exists in the international arena. And the various fields in the international arena have been carefully delineated by Professor Lewis in his presentation. They are three. Is the deliberate, intentional killing of another justified upon a theory of self-defense? Is the deliberate killing of another justified because it occurred in the context of armed conflict? Finally, can it be justified outside of armed conflict under standards that are described under the heading of international human rights law? And those are the propositions that we will be exploring in more detail as we go forward. In my view, this debate that we're having today and that took place recently between the two candidates for president, and that we see debated in our press and in the commentariat, presents an intersection, a conflict between two basic propositions. One proposition is what our gut or our stomach tells us is the right thing to do. It tells us what we want to do, what we're impelled to do because of certain circumstances on the ground. The other proposition is what our legally trained head tells us to do, operating with what we hope to be cool, intellectual, objective detachment. And our head tells us that we must take account in making judgments about the intentional killing of a human being in the context of law with our values, our ideals, uppermost in our minds. And I want to state in that connection two or actually 3 propositions, but 2 overarching principles. These principles are absolutely fundamental to our way of life as Americans in this country. Proposition number 1, stated by Justice O'Connor in the Hamby case, which was one of several cases in which the practices and policies of the Bush administration dealing with the global war on terror were challenged, stated the notion that, the crucially important notion, that a state of war is not a blank check for the president when it comes to the rights of a nation's citizens. This is basic law in our country. Our Constitution is founded upon the notion of a separation of powers, the notion of checks and balances. And that's the proposition that Justice O'Connor was stating. Of equal importance is the notion expressed by President Obama at his inauguration in January of 2009. He says, as for our common defense, our security, our safety as citizens, we reject, he said, as false, the choice between our safety and our ideals. All of us, citizens of this country, people who were around at the time of 9/11, remember what it was like. Remember the threat that was offered to us, potentially personal, by subsequent attacks. Security was very important to us. President Obama recognizes that clearly, but in his statement, at least as I read it, he says we must, even though we're concerned about our safety, be sure that we do not forget our ideals, our values. And I'm going to come back to that proposition going forward, and it's one that I'd like you to remember as we go forward and we consider the approach that has been taken by the current administration with respect to targeted killing. And it is that approach that I believe marks, or may mark, I don't know, see, a difference between Professor Lewis and me about the manner in which, under law, the subject of targeted killing must be addressed. The last statement is one that came from the New York Times that appeared in the editorial a week or so after the reporting by 2 New York Times reporters that President Obama himself was involved in the decisions to kill individuals who were perceived to be enemies of the United States. And they offered the notion, the Times did, that the U.S. cannot be in a perpetual war on terror that allows lethal force against anyone, anywhere, for any perceived threat. Their point was that's too much power. And I agree with that proposition. I think that we need new standards to address the war on terror. And I'm talking about off the traditional battlefield. I'm not talking about where opposing forces oppose one another. The one force is here, the other is 100 yards, 100 miles away, within technological sight, or the taking of a beachhead or the capture of a hillside. In that context, the rules that exist now are fine. I'm talking about standards that are needed for war that takes place off the traditional battlefield. Professor Lewis in his commentary offered a suggestion, which is as sensible as any in terms of treating the transnational phenomenon, but it's a mere suggestion. It doesn't yet have the force of law. The rules that are in place now, the IHL rules, are ones that were adopted decades ago. The most recent set of rules was adopted in 1977. Before that, 1949. Before that, 1907. That's a long time ago. And all those rules were adopted, at the time they were adopted, in the light of circumstances that existed at the time those rules were adopted. Those circumstances have changed. They've changed dramatically. We now have the phenomenon, we're all painfully aware of this, of the transnational non-state actor. It's not that it's brand new as of 9/11, but it's a new phenomenon that struck us like a fist between the eyes on September 11th. Us as a people, everyone in the world. And the question became, with respect to this transnational, non-state actor, what to do. And remember, this group of people, Al-Qaeda and their ilk, operated differently than the classic armed conflict. They were driven by an ideology. They had no loyalty to any particular place. They operated where they could operate, whether it's Afghanistan or Yemen or Somalia or wherever. They killed without regard to innocent life, even their own people. It's a new phenomenon that has to be addressed. And in the middle of September of 2001, the Bush officials, needing to find a response within the framework of a rule of law, sought to make a judgment about how to address this threat. 2 buildings knocked down, 110 stories. The Pentagon attacked, thousands of people killed. Something had to be done. A legal structure had to be designed to address this threat. In the past, ideological malefactors were treated under criminal law. The Badenhof or Bader-Meinhof gang in the 70s, Red Army faction and others were treated under criminal law. But that did not offer, at least in the judgment of the Bush officials, and that judgment has been confirmed by the Obama officials, sufficient latitude to address the phenomenon of the transnational actor. And what happened was that a broad design was created. We can go after these folks under criminal law if we elect to, although that offers very narrow opportunities for reasons that Professor Lewis explained. Or we can go after them under a broader umbrella. We can declare this now and forever to be an armed conflict. And within the context of armed conflict, if the person is a combatant, is a fighter, he's targetable, and legally so. The adversary has a right, a legal right, to target, to kill the combatant on the other side. There was more flexibility for the United States that existed under IHL. And so now, you see, whenever the issue arises, whether it's Holder or Coe or Johnson or any other, Brennan, any other high-level United States official, the action is always characterized under the heading of we're at war, and we have a right, because we're at war, to attack the individual anywhere, any place, based on our perception of the threat to the nation. Now, as Professor Lewis explained, these issues arise in a variety of contexts. When is an issue? Where is an issue? What or who is an issue? I'm going to focus more on the who now than the when or the where. I think there's ambiguity aplenty in terms of the when and the where phenomenon. As I say, the solution that is offered by Professor Lewis is a reasonable one, but has not been adopted as a principle of law which binds other nations. I want to focus on the who, the identity of the target. I want to talk to you about who decides these questions, the when, the where, the who. And then I want to have a word on the reliability of data. That's a very important proposition. Every time you hear any of these officials that Professor Lewis identified and I just mentioned, every single time they will say the reason why drone strikes, talking about drones, the reason why drone strikes are the way to go in the context of armed conflict or self-defense is they're surgically precise and effective. And they have minimum collateral effects, i.e. that's IHL speak for not too many civilians get killed. Some get killed, but not too many, not excessive. And this proposition, this fundamental proposition which underlies the administration's use of drones in various contexts was declared by an exhaustive study done by Stanford and NYU, just completed, just published within the month. That dominant narrative was declared to be false. One of the reasons why it was declared to be false was that, at least a couple that I know here. One is the trade-offs. The administration takes a position it can target, it can kill Al-Qaeda personnel, if I may use that word in connection with Al-Qaeda, and associated forces. The question is, who are these people? They're not in the phone book. They're not readily identifiable. We know they have been identified, some of the principals, but who are the rest of them? Who are the associated forces? Who's to say who they are? According to this report by Stanford and NYU, what has happened is every once in a while, who knows how often, we don't have access to the facts, every once in a while, the ISI in Pakistan or some other group will say, so-and-so is associated with Al-Qaeda, go get it. And we, sometimes, we don't know how often, wittingly or unwittingly, we don't know, target this individual. That's one problem. The other problem is the manipulation of the data. Minimal collateral impacts. That's good, right? IHL says you can engage in war, but do not do so in such a way as to cause excessive harm to protected persons, civilians, or objects, which are non-military objectives. The CIA understands that principle, and they define combatants or fighters or targetable people in a particular way. If you happen to be, and every man in this room qualifies, I believe, I don't want to do, but everybody else does, if you happen to be of military age, you're a combatant, ipso facto. And if you happen to be killed in one of these attacks, civilians haven't been killed, no, combatants have been killed. And through that device, the number of people that have been collateral damage has been limited. That's what is reported in the New York Times. Again, one of the problems is we don't have access to the data. The Obama administration, for good or ill, is withholding that data, just as the Bush administration did before. The New York Times, the ACLU, two special rapporteurs, the UN, are trying to get that data, but so far, no go. The criteria for killing. Mr. Holder, as Aslam pointed out at the outset, and as you probably know, appeared 100 feet from here a few months ago and identified the criteria to kill people. He said specific senior operational leaders and associated forces presenting an imminent threat of violent attack are targetable anywhere, anytime. And he's concerned about due process, as well he should. He's the Attorney General. said that if it's an American, the person, in addition to those other features, we've got to determine that we can't capture them. And also, by the way, IHL principles apply. Now, I emphasized certain words here because I wanted to make the point that these are sensitive issues. And remember, the decision on this determines whether somebody's going to be killed. What is it operationally? It is, under traditional notions of IHL, permissible to target a person who is part of a so-called continuous combat function. The word that's used here is operational, suggesting a good deal of latitude. Is the person involved in financing an operation targetable? Is the person involved in logistics targetable? We don't know. All we know is the person is operational. Associated, again, is a big question mark. What does that mean? Who are these people? Is it an association, an affinity that lasts a week, a day, a month? Is it more substantial, less substantial? We don't know. These judgments are left to the Attorney General and others acting alone in their wisdom. Could al-Awlaki have been captured? We don't know. We're told no, but we don't really know because we don't have the facts to make a judgment. Which gets me to my next point of who decides, which to my way of looking at these propositions is of critical importance. The Attorney General told us the answer to that question. He said, I, the Attorney General, will decide. The conduct and management of national security, he said, are core functions of the executive branch. We'll decide. We're the only ones that can do so. Things are fast moving. Leave it to us. And then he said something that I found perfectly astonishing. And I hope many of you did too. And I still do. The Constitution, he says, guarantees due process, not judicial process. I must tell you, dear friends, that bowled me over. To me, when I think of judicial process, it forms a central and indispensable part of the rule of law. If I don't have the capacity, as a citizen of this country, to challenge the actions of my government through some body that's independent and neutral and fair, there is no rule of law. If I have to depend upon the goodwill, the honesty, the integrity of an executive with respect to who gets killed and who doesn't get killed, particularly if it affects me, there is no rule of law. My view of this matter, I'm sure this must be apparent to you by now, is that the executive should not have a blank check regarding targeted killing off the traditional battlefield. Again, I'm not talking about the situation having a judge sitting by the second lieutenant in the foxhole or writing the wingman to the operator of an F-16 warplane. I'm talking about decisions about killing somebody well removed in time and space from the traditional battlefield, when there's some time. Holder says that there's no time. But if you look, and maybe some of you have, if you haven't, I recommend it, if you look at the Brennan report, which he issued, he's the counterterrorism guy for President Obama. This was issued in the end of April of this year. And he describes an elaborate process of review. Is it the right, I mean, it's an IHL review. Is it armed conflict? is this a legitimate target? Are we being sure that the damage, the harm to civilians is as limited as possible? Are we applying proportionality? Just using the right amount of force and no more to accomplish our end? That's the process that Brennan describes. That takes time. And then in comes the president at the end, the top man, the chief executive of the country, comes in and makes the decision at the end of the day whether this action is maybe justified. That takes time. Time enough, in my view, for some form of review. We have that review in other contexts. I was a prosecutor in an early life. Had to get a judge involved to get a search warrant. Had to get a judge involved to get a wiretap. You need to get a court involved to engage in the interception of electronic interception of telephone messages under FedSoc, which has now been modified and which is under review in the Supreme Court. So my proposition is executive power should be subject to some form of review. In our system, I have faith in the judiciary. I recommend, and I'm hardly alone, that the review be judicial. But there should be some form of reliable, independent monitoring. Got to be aware of security. It's a legitimate concern, but there should be. I'm about to get the hook here, so I'll wrap up. There's got to be some form of independent monitoring. Just the other day, there was a report in the paper. 2 UN special rapporteurs said that if you won't do it, we'll try. Good luck with this, but we'll try to require that this information be disclosed through what they call a special investigative unit operating out of Geneva, the Human Rights Council. As I say, good luck with that. But anyhow, the rest of my slides deal with many of the propositions that I think that Professor Lewis has outlined for you very ably. There are points of difference between us in terms of the who, what, when, and where. But I think we probably agree that when we're talking about dealing with this transnational phenomenon, we're talking about making up the rules as we go. Harold Coe, legal advisor to the Department of State, said as much when he was talking about trying to fit rules devised in 1949 and 1977 to meet a phenomenon of the new millennium. He says, we got to translate. That's his word. We've got to engage in the process of translation of the old rules to fit the new situation. To me, it looks like a process of trying to put a round peg in a square hole. I think there needs to be a definition of the who, the when, the where in this new context. So, and we also need to have the benefit of independent monitoring of the process, so that we have confidence as a people that these important values that Obama identified in his inaugural speech are preserved. Thanks.
Okay, we have time for about 15 minutes worth of questions. I'd be very grateful for any questions you guys have. Anybody? Okay, in the back.
You mentioned that in your framework you can only use it when you had permission from another country or if they were unwilling or unable to go after in their own country. Can you describe a situation where they would give you authorization if they weren't also unwilling or unable? They would just automatically be unwilling if they didn't give you authorization? Can you answer that question?
Well, yeah, if they don't give you authorization, then they are definitionally unwilling. And it's the Uruguayans saying you can't come in and the Graf Spee can stay as long as it wants. right? Or it's the Pakistanis saying, or effectively saying, yeah, bin Laden's been half a mile from our military academy for the last 7 years and we haven't done anything about it. That is almost definitionally proving to be unwilling or unable because, you know, you can't figure out where he is. But in either case, you would say that we were using, because we use force without Pakistani permission on Pakistani territory. That is illegal in international law unless we have some legal basis for it. And I would argue that the legal basis was probably just that. They were unwilling or unable to deal with a belligerent on their territory, and they had proven themselves so by their, you know, extended conduct of not doing anything about it.
It's an extraordinary, if I may respond to the question as well, in many ways it's quite an extraordinary doctrine that force is justified. The United States can use force, defensive force, vis-a-vis another nation if that nation proves, in the eyes of the United States, to be unwilling or unable to deal with this perceived threat to U.S. interests. That's an enormous power that the United States arrogates to itself. The situation in Pakistan illustrates the problem. I don't know whether you noted in the press recently, there was a dispute about whether the consent is genuine. Used to be, we'd send a fax, we're about to send drones in, clear the airspace, there would be an acknowledgement of that fax. Then, after bin Laden, Pakistan got angry at us. Who knows what went on behind the scenes, but they no longer responded to the fax. Is it still consent? We thought so. We continued to mount the drone attacks in Pakistan. The airspace continued to be cleared. We figured, all things considered, that's consent. It's illustrative of the problem that I described before, that lethal force can be released on the say-so of our government. And I've got no quarrel with the Obama administration. Good people, well-intentioned people, honorable people. But that's too much power. Yes, sir.
Mike, one thing I would say to that, briefly, we have always released force on the say-so of our government. That's the way our system works. Attorney General Holder was absolutely right that that is a core function of the executive branch. Once Congress says you have the power to use the laws of war, the AUMF, right, these are the people you can go after. And the judicial gloss on this, if you read all the habeas cases, is Al-Qaeda and associated forces. This isn't something the executive made up, it's something that the judiciary has said. The executive then has the right to go and make decisions. The executive, being a second lieutenant in Afghanistan or whoever else, makes those decisions all the time. Which house are you going to? I'm going to go to that house. Why? Because I've got intel from these guys that that's where the bad guy is. That is an executive decision that gets made without any reference to the judiciary. And the only way that you stop that executive decision is when Congress removes the power it is granted to the President. And you can do that any time. We want to remove the term associated forces. We want to remove Al-Qaeda. We want to say not in Pakistan. Congress can do any of those things and restrict the executive's power of its war-making force. But we have never had the judiciary saying, oh, and by the way, before you go and use this force, you need to check with us. Go ahead.
So, question: when you go in, or when we determine that someone is a threat to our national security, especially in a situation like we have now, if a country, let's say we find someone in France who we think is a threat, that's a French politician.
Right.
If they all of a sudden disagree with that statement, we think that they're national.
They disagree and say what?
That's my question. If they disagree, that they feel that that person is a threat to our national security.
And they withhold consent?
That's their only option, is to just withhold consent? Or is there any form of opposition they can make, say, whoa, time out, we don't think this guy's a threat to your national security? Is there any type
Well, I mean, withholding consent would be part of it, saying you may not use force on their territory, right? The French say that, and we are bound to honor that. Now, if it was, for example, let's say it's Osama bin Laden, who is in France. If he were still alive and he was walking through the streets of Paris, and we said, get him, right? I mean, that's the first thing you do. You go to the nation and you say, get him, or get him off of your territory. And if they say no, then we would say, why not? You know, why do you say he is not a threat to us? And if they can't give a reason why he's not a threat to us, but they won't give us permission to come in, then I think we have the right to go in. No, we have to clearly identify this is why he is a threat to us. This is why he is an operational leader that is an imminent threat to us. And we make those points, and then if they say, no, you can't do it, then
we still go in.
Well, I mean,
we don't necessarily, because as Professor Lewis says, there are two aspects to this: unable or unwilling. The practical matter, as a practical matter, there is no way the United States is going to judge that France is either unable or unwilling to address the problem occurring within France, even though we have the notion that the person, one individual facing a nation of 300 million with a defense budget in the hundreds of billions and all kinds of planes and boats and what have you, represents a real threat. We're not going to invade France. Simple as that. Pakistan is different. Other countries, Yemen and others, are different. That's one of the difficulties in the area of defining these concepts of unable and unwilling, although it's less significant than in other areas.
flip side of that is I can't imagine that the French wouldn't cooperate, right? I mean, that's the difference between Pakistan and Yemen, who clearly may or may not cooperate. It's unimaginable to think the French would say, screw it, we are not going to let you have him. We don't think he's a threat, and we don't care why you think he's a threat. That's hard to imagine as well. And so I would suspect that ends with him being picked up either by the Sûreté or by the U.S. with French permission.
So just out of curiosity, turning the tables, if that happened in the U.S. and another country, say China, so we were harboring someone that they felt was a threat to their national security, or we there was an American who was a threat to their national security to some degree or another.
Two-way street, isn't it?
Yeah, absolutely. And what we'd have to do is we'd say,
That's part of the
here are the and it's fine for them to do that. For them to say, here are the reasons that we think he is a threat to our national security, and we can judge them and say, we disagree. If you want to come get him, do it over our dead body, or we could give him permission. Come and get him, or we will deliver him to you. Right? We agree that he is a threat to your security, and you have a right to have him back. We get to make that decision, and we get to say, yes, you have permission, no, you don't have permission. And if they go ahead and do it, then that's an act of war. Pakistan could view what we did in Pakistan as an act of war.
There's a man with a question in the back here.
Okay.
Yeah, so do you think what happened in Pakistan, it was legal in international law? I mean, the United States certainly didn't go to Pakistan and say, we're going to take Osama bin Laden because I think he was there. They did it without permission. So do you think it's legal?
They did it without permission based on, I think, the circumstances indicating that Pakistan was unwilling or unable. The problem is there had been indication at other times that when we'd informed the ISI, sometimes the people were no longer there, right? The ISI could get to them and get them out or notify them that they were in danger, and they disappeared. And bin Laden was too great a target and too big a deal for us to risk. And it's almost impossible to believe that he could have been there without the knowledge of people in Pakistan. And if he's there for 7 years with their knowledge, they are definitionally unable and or unwilling to do anything about it. And that's why that standard's so important, because otherwise we would have to say, Pakistan, we're coming to get him. You want to disappear him so we can't get him? Go ahead. And
A couple of propositions I would offer. I don't know how much time we've got. A couple of
We
other
have
questions.
until about
But 5 or 6
1:20,
minutes.
Okay. There are two bodies of law that are involved here with respect to the Pakistan or any other country situation. One is the use of force justified vis-a-vis that nation. And with respect to that proposition, we have the principles that both Professor Lewis and I have discussed: consent, genuine consent, failing that, evidence, reliable evidence that the nation is unwilling or unable to cooperate. The record is mixed with respect to that question of whether there was consent in this case, but whether there was a justification to kill bin Laden is a separate proposition, which must be judged under IHL or under international human rights law. And as to that, we would need at least another 30 or 40 minutes before that. But I just wanted to be clear, two separate propositions of law. Yes, ma'am.
Professor Lewis, can you discuss the status of a target as a U.S. citizen and how that affects your analysis? Because it seems like that's when maybe the executive versus judicial power would shift a little bit. I mean, I guess specifically with Al-Awlaki, how did that?
Well, with Al-Awlaki and the Holder and Brennan and others have described in detail, these are the things that we do. This is what they have to meet. They have to be operational. They have to not be capturable. They have to be an imminent threat, but imminent, it does not mean today. They don't have to be in the process of doing something right now. We get a window in which we've been trying to get Al-Awlaki for like 8 months. It's very hard to find these people, and you get a window in which you can get them for an hour or two, and then you've lost them again. And so you get a window, and Holder and Brennan have both said we don't have to pass that window up just because at that moment they're not on the phone with somebody who's about to blow someone up. So you get a window like that, and I don't think that, I agree that it would be nice to be able to have some kind of review. The ex-ante review is very difficult, though. There may be time and there may not. If you start saying ex-ante review is required, then the there may be time doesn't wash, right? You have to say, in all cases you get this, or in all cases you don't. You can't say, well, it's up to the executive as to whether they want to give you the ex-ante review. You can't do that. If we're saying the judiciary gets involved ahead of time, it's got to always be the case. And there are some times in which we don't have time to do that. Now, and that's American citizens as well. I agree with that. In fact, I mean, if you take my my proposition there to logical conclusion, it wouldn't have mattered if he was in this country. If he's in this country, in the uniform of or acting as a continuous combat functionary of a foreign power or a non-state actor that is engaged in an armed conflict with us, we can kill him. We do not have to capture him. It wouldn't make any sense to kill him because the intelligence value of capturing him is much greater. And I have no doubt that we would capture him anywhere in the United States. But I don't think there is any necessity that you capture rather than kill him if he's a positively identified individual that meets the criteria that the executive has. And with regard to people like the special rapporteurs saying the United States must give up the criteria that it uses, and it must describe in detail how you get on this list and what you have to do to that list, and tell the world that, is ridiculous. If you're telling the rest of the world this is how you become an enemy, then the rest of the world says, okay, well, this is how we're going to gain that so that we don't fit within these criteria, and we'll keep doing what we're doing. And no other nation in this world has ever been asked by anyone to do that. It's only because it's the United States that the special rapporteur has anything like this kind of interest.
But if you had Al-Awlaki and then his AQAP equivalent that's just not a U.S. citizen,
Yep.
do you think that they should be
Yes.
addressed any differently?
Life's a life. I don't think that American citizens are entitled to any greater respect for their lives than others are. If we're taking a life, you have to take that just as seriously if it's a foreigner than it is if it's an American. I understand U.S. constitutional protections are greater in some areas. I think if you're taking a life, you have to take that just as seriously in either way.
Let me just comment, because it looks like we're out of time. I think the central thing that I hope emerges, and I think the questions that have just been put highlight the proposition, that there is time, when you consider very closely the circumstances, for the interjection of a form of review if we're talking about targeting somebody for killing off a traditional battlefield. Killing Milwaukee in New Jersey or wherever he may be found, or Yemen, under the standards identified by the Attorney General, require a number of discrete judgments to be made. And we are used in this country, we're well used to the idea of having a judge step in and review those criteria and decide whether upon facts action can or should be taken. When I functioned as a prosecutor, we would get search warrants at 3 in the morning on a Tuesday. because the process was set up to manage that within a half an hour by going to a judge's home. There's no reason, given the process that Mr. Brennan described, why there wouldn't be sufficient time for that kind of ex-ante review when we're talking about such a serious consequence of killing somebody. I'm not saying the people we're seeking to kill are innocent lambs, far from it, but nonetheless, our values matter.
Got a question?
Final question, we have like 1 or 2 minutes left.
Yeah.
Going back to the France-Europe analogy, I understand that the US has rendered a number of individuals from Germany without German consent. As far as I'm aware, they don't kill, I'm not sure about that. Presumably, Germany is willing and is able. So would that constitute an act of war, or what was the...
You said rendered. I mean, you're talking about people that I think you're, Al-Masri might have been one of them, but that there are a couple of German nationals that were captured elsewhere.
No, I mean
that,
from within the states of Germany.
from within Germany, and they were captured by U.S. personnel without German knowledge or permission?
That's correct.
That would surprise me, but I guess it's, I mean, if it's possible, then yes, Germany would have a complaint if we are doing that on their soil without their knowledge or their permission. So these are CIA that are getting them, or?
Yeah.
Okay. Well, yes, I think Germany has an international law complaint that you are violating our sovereignty. If in fact we don't tell them and we go and do it without permission or anything else, yeah, I think that's a problem.
Well, the killing, I mean, the case that raises this question, Mr. Mabhood in Dubai. He's in a hotel room in Dubai, and he is smothered, presumably by, we don't know for sure, by Israeli agents, based upon the allegation that he was an operational figure in terms of challenges by in terms of the security interests of the state of Israel. I mean, that carries to its extreme the time and place and who criteria. I mean, the who could occupy us again for 20 or 30 minutes. Who is a civilian actively taking part in hostilities? Large subject matter, still not defined as a matter of law. The ICRC has come forward with guidelines, but those aren't legally binding now. And in this world where we're plagued by, threatened by entities like Al-Qaeda and associated forces, we need rules and we need review. And we probably need to come to an end.
One over here? Or?
No.
Done? Okay.
We have to sorry. Thank you so much for attending, and hopefully we'll see you next semester. I have some Mountain Dews here that haven't